Hi, my name is Shannon Borden. I'm an estate planning attorney here in Las Vegas. So at this point in our video series, we've talked about my personal experiences, the traditional law firm, and why my firm is different, and we've covered some of the most common myths in estate planning, which is the beginning of your estate planning journey. Now let's talk about the nitty-gritty, the actual nuts and bolts of estate planning. So we'll start with some of the most common questions that I get from clients about estate planning. One of the questions I hear a lot is, what is a will? So we briefly touched on this in my other videos, and we talked about it in the most common myths in estate planning. But this is really an important subject, so we should talk about it again. A will, meaning your last will and testament, is a document explaining who gets what stuff and who is in charge of making that happen. A person you name in your will to receive your assets is called an heir or a beneficiary. And the person that you put in charge of making that happen is referred to as a personal representative or an executor. And most people think that a will is all they need, that it will do everything that they want it to, but it doesn't. For instance, a will does not apply to all of your assets. Let's talk about retirement accounts and life insurance policies that have beneficiaries, which means those accounts and policies will be payable directly to those beneficiaries. And that may be different than what you put in your will. And that's why if you have a will, it's important to make sure that it's in sync with your wishes for your overall planning, so that all of the parts of your plan work together the way that you want it to. A will also won't keep you out of probate. Again, I say it a lot of times. All wills get probated. Your will must be filed with a probate court. The probate judge then reviews and approves the will before your executor or your representative can act on your behalf, and then ultimately distribute the assets to your loved ones. And that's if the judge accepts your will. So a will is only guidance for a judge. A judge has the discretion to make their own decisions, and their decisions may or may not align with your will. And that's why you want to completely bypass the probate process. You don't want to deal with the time, often years, or expense, thousands of dollars, or the stress and conflict that probate can cause. You don't want your assets to become public knowledge or your beneficiaries to become public knowledge, which also includes your underage children, by the way, which can make them vulnerable to predators. At the end of the day, you don't want a judge stepping in and making decisions that you would not want made. A judge doesn't know you, and they don't care about you or your family. And the only way we can avoid the mess of probate is with a trust. So the next question I often get is, do I need more than a will? You don't want that messy, expensive, stressful probate process that we just discussed. So if you have assets, a home, a bank account, a life insurance policy, a retirement account, then you do need more than a will. You need a trust. But you also need to consider incapacity or disability during your lifetime. So a will simply states who gets what, but that's not your only concern when you think about your estate plan. Estate planning covers not only what happens after you die, it also covers incapacity during your lifetime. For example, who's in charge of your assets and your medical decisions if you're incapable of making them? And incapacity and disability may include a great many things. We most often think of incapacity as a coma, or Alzheimer's, or dementia, but incapacity or disability can encompass much more than that. So yes, you definitely need more than a will to protect yourself from probate and to protect yourself during incapacity, so that you can protect you and your loved ones when you're no longer here to protect them yourself. So the next question I get a lot is, what is a living will? So there is a lot of confusion about wills because there's more than one type of will. That's why a living will is often confused with a last will and testament. A last will and testament is the will that we just covered, the document that describes who gets what when you die. A living will, which is also known as an advance healthcare directive, applies to incapacity. In other words, a will goes into effect after you die, but a living will can take effect while you're still living, in the event of incapacity, where you can't make decisions for yourself. Your living will sets forth whether you wish to be resuscitated or intubated, whether you want to be kept in your home, whether you want pain management or other treatment to keep you comfortable during incapacity. The idea with incapacity planning is that you get to make these decisions ahead of time. So when the bad things happen, your loved ones know your wishes and only need to follow the plan that you've already set forth. It will also keep your family out of conflict because you decide in advance who is in charge of making sure those decisions happen the way that you want them to. That way, it's not left up to a doctor or a judge. If you think of the Terri Schiavo case, this is a perfect example of why incapacity planning is so important. And then I also get questions about what is probate. Now, I've mentioned probate quite a bit throughout my video series, and you've heard me say how awful probate is. It's expensive, it's time-consuming, it's stressful. It's a very public court process where a judge makes all of the decisions about your estate. But let's take a deeper dive into what probate actually is and what will happen to your loved ones and your estate if you have to go through probate. So probate is the court system we have in place to deal with our assets and belongings when we die. It's really meant to ensure the proper succession and distribution of our assets if we have either no planning in place or if we just have a will. I mention this all the time, but it bears repeating. All wills get probated. What this means in practical terms is that probate isn't an estate plan. It's the default if we don't have proper planning. If you haven't done estate planning to avoid probate, you're leaving it up to a judge to make all of the decisions for you. They will select your beneficiaries and decide the split of assets between them. They will select the executor of your estate and any other decisions related to the disposition of your estate. If you have a will, the judge might use your will as guidance, but a judge is not required to follow the wishes in your will. They can make decisions completely contrary to what you actually want. And that's because probate is a public court proceeding. And like any public court proceeding, all of the records of your probate are made public. This includes all of your assets and your beneficiaries. And this can leave your beneficiaries vulnerable to predators who want to take your assets from them. Again, probate is also expensive and time-consuming. It can take up to 2 years to complete, and especially here in Nevada. And probate will cost thousands of dollars. And because none of your loved ones will see a penny of your assets until probate is finalized, your loved ones are going to pay for everything out of pocket. This includes funeral and memorial arrangements, court costs, filing fees, assessor's fees, executor's fees, a probate attorney, and much more. And if your probate is contested, meaning your loved ones are fighting over your assets, it will take even longer and be even more expensive. But the good news is you can avoid all of this with a trust. And a trust is the only way you can bypass the probate process completely. And that's because a trust is a private transaction, meaning everything is handled privately, nothing is made public. And the process starts immediately. There is no 2-year waiting period before assets can be distributed. Everything happens right now, in real time. A trust will keep your loved ones out of court and out of conflict. It will ensure that everything happens the way that you want it to when you and your loved ones need it most. Another question that I frequently get is, what is a trust? So a trust is a substitute for a last will and testament. We've basically covered what a will is, and it lists who gets what and who's in charge of making that happen. But a trust does much more than that. In a trust, you get to make all of the decisions a judge would make during probate. But you get to make those decisions before you die, eliminating the need for probate. One of the most important differences between a will and a trust is that a will has to be publicly filed with the probate court, then reviewed and approved before anyone can act under it or receive any assets from your estate. A trust, on the other hand, does not get filed anywhere. You do not have to share your trust or file your trust or give your trust to a court. In fact, you don't have to share your documents with anyone. You don't even have to tell anyone you have them, or even who gets what, if you don't want to. Your trust documents are completely private to you. They are shared with your trustee, the person in charge of administering your trust, sort of like an executor in a will, but they are only shared after you are no longer here. Instead, we send letters to people you've named in your trust to tell them they may be called upon to act, that they may have a role in administering your trust, or assisting you as a power of attorney in the event of your incapacity. This lets your loved ones know that you have planning in place in the event of your incapacity or death. So a trust is a completely private document that provides for immediate and efficient distribution of your estate, the complete opposite of a will that must be probated. And of course, I always get asked, aren't trusts only for the wealthy? Many people believe that trusts are only for the rich, or only if you have a net worth of X number of dollars or more. This is simply not true. The decision to create a trust has nothing to do with how much you own, or might own, or your net worth. It's really about how you want to pass assets to your spouse and to your loved ones, making sure everything happens privately and immediately the way that you intend, without going through the probate process. But it's truly up to you to determine what planning is appropriate for you and your particular situation. My job is to educate you about the decisions you can make with respect to your incapacity and death, your overall estate planning, to give you the options to make decisions now and then get your comprehensive plan in place so that you don't have to worry if your loved ones will be taken care of in the event of your incapacity or death. It's all about empowering you to make well-informed estate planning decisions and giving yourself peace of mind that everything will occur the way that you design it when you need it the most. Another question that I get very often is, isn't estate planning only for older people? So this is a great question. Estate planning isn't only for the elderly. It is for young people as well. We frequently hear stories where someone in their early 20s or 30s gets into a car accident and they either become permanently disabled or they die. Let's say that you're in your 20s or your 30s and you get disabled and you have no incapacity planning. Your loved ones will have to go to court in order to make medical decisions for you. This means your parents too. Now, most parents believe that if something happens to their child, they can automatically step in and help. And most children also believe their parents will always be able to help them. But this is absolutely not true. As soon as you turn 18, your parents and your loved ones cannot obtain your medical records. They cannot assist you with your finances, and they cannot make medical decisions for you even if you wanted them to. Your parents and your loved ones will have to go through the court guardianship process in order to be able to make medical and financial decisions for you while you're incapacitated. And the court may not elect the person you want most as your guardian. In fact, the court can elect whomever they want to serve as your guardian. And if the guardianship is contested, meaning your family and your loved ones don't agree on who should be your guardian, then it will take even longer for the court to make a decision. And again, the person elected may be someone you don't want to make decisions for you. So this is an awful lot like the Terri Schiavo case. Terri was in her 20s and in a coma, and her family couldn't agree whether to take her off of life support. It's commonly referred to as pulling the plug. It became a national news story with family members, loved ones, and members of the public on both sides. those who felt Terry would not want to live in a vegetative state, and others who felt that no one had the right to end her life, not even if that's what she would have wanted. Now let's say you've been on life support for a few years while everyone is fighting over what to do, and you end up dying before the guardianship process is finalized, and you have no estate planning in place. What if you're a single parent? Who would you want to raise your child? Who would you want to have control of your finances and your assets? If you have no estate planning and your estate ends up in probate, someone you may not want to have custody may get custody of your children. And what if the family member you don't trust to help your child, someone you don't trust to make sure your assets go to your child, ends up being the trustee of your estate? And it could be the same person for both roles, trustee of your estate and the family member that raises your child. And you will have zero say in the judge's decision. But with the proper estate planning, you can make sure that these things don't happen. You get to make all of your decisions now, and you can amend or modify those decisions as your life changes. So throughout your lifetime, you get to ensure that everything is handled the way that you want it handled if bad things happen. If you are a parent with underage children or adult children, ages 18 to 26, please make sure you watch my video on guardianship nominations and college age packages. I take a deeper dive into what you can do in order to protect your children in the event you become incapacitated or die, or they become incapacitated and need your help. Another question I get very frequently is, what if I want to do it myself for my estate plan? So please don't do it yourself when it comes to estate planning. Estate planning is much more complex than you may realize. There are a lot of contingencies to plan for. How you pass assets to your spouse when you're no longer here. How you pass assets to your loved ones when neither of you is here. And this is very complex when we factor in taxes, legal nuance and law, and the people we elect to administer our estate. And also the rules they need to follow to ensure our estate is properly managed. You cannot simply plug a name and a date into the same document everyone else uses and hope that it will cover all of the things that you want to plan for. It's not simply a matter of signing a document you found on the internet, because there are so many factors to address about your future, your spouse's future, and your loved one's futures, and your legacy. It's more than a fill-in-the-blank cookie-cutter document can address. We're here to ensure that your plan is fully customized to you and your particular situation. We design your plan around your wishes and address your concerns, including what's important to put in your legal document, how to keep your family and assets protected, and how to ensure your plan works like you want it to when you need it most. And a fully customized plan is the only way to ensure complete peace of mind when it comes to your estate planning. I also get the question, why is incapacity planning important? And we've touched on this a lot. But just to be clear, most people believe that if they are married and become incapacitated or disabled, their spouse can automatically make medical and financial decisions for them, which is not true. Even though you're married, the law does not presume that your spouse has your best interests at heart. Most people are really shocked when they hear that. But again, how can we not have our spouse's best interests at heart? But what happens if you're separated or estranged from your spouse? What if you think your spouse would pull the plug just to get your money and your assets? The law wants to protect us from situations like these. That's why the law does not presume that our spouse is the one person who knows what we want and acts with our best interests at heart. But on the other side of the coin, this means that without the proper planning, your spouse will have to go through a court process of guardianship, which will not only cause delays in your medical and financial decisions, it may also result in someone you don't know making decisions on your behalf. And this is because the court does not automatically elect your spouse to act for you. The court may elect someone of their choosing to make decisions for you instead. That means a judge can elect someone other than your spouse to act on your behalf. Someone you don't know, someone you don't trust, and someone you would never elect for yourself if you had the choice. It's pretty scary, right? And that's why it's very important that you get all of your incapacity documents prepared in advance, so there are no delays in your care and no decisions made on your behalf by people you don't know or you don't trust. And that actually goes for everyone, not just married couples. So one question that I get a lot is, how can I avoid paying taxes? The simple answer is, you can't. Uncle Sam always gets his cut. But there are some ways that we can mitigate taxes when it comes to our estate planning. There's also some good news here. So in the state of Nevada, we do not have a state inheritance tax. So the only taxes that we need to be concerned about in Nevada are those that have come from a federal level. There are some options we can discuss when it comes to mitigating the taxes that you pay. And these options are very case specific. In other words, we need to meet in order to discuss your particular situation and the options that we can add to your plan, because not all options are right for you. But I do want to give you a basic overview of what those options look like. There is a way to mitigate taxes during your lifetime with a Nevada Asset Protection Trust, which is an irrevocable trust. There's a lot of planning that goes into an NAPT, and that's why I discussed this issue in a separate video. We can also add a family trust to your estate plan. Again, this is a complex option that we should really discuss in person. But this is also an irrevocable trust. We can add this to your plan if you're married, so that when the first of you dies, the surviving spouse can split the assets into 2 different trusts in order to avoid the federal estate tax. It has some other benefits as well. There's another option that we can add for the surviving spouse to divide their survivor's trust. So some assets stay in the survivor's trust, and any assets the surviving spouse needs to disclaim go into another trust called the marital trust. There are also trusts that you can add for your beneficiaries either with special needs or for those beneficiaries you want to have asset protection. I know this is confusing, and that's why it's important that we meet to discuss these options. When we meet, I'll draw a diagram to make it easier to understand these concepts, and I can answer any questions that you might have. It will make more sense when we talk about it in the context of your particular needs. So these are some of the most frequently asked questions that I get from clients. And I know, again, this is a lot of information. I don't expect you to remember everything that we just covered. I also expect that you have even more questions now than you did before you started watching this video. That's okay. That's what I am here for, to help walk you through all of your options and figure out what is most important to you, for you and your loved ones. Please take advantage of my free consultation. I would love to answer your questions in person and help you design a fully customized package based upon your unique situation. You can schedule an appointment online at www.bordenlawnv.com, or you can call my office at 702-582-9780. I look forward to seeing you soon.